I'm Melvin Raymond, attorney and counselor at law. Welcome to Raymond Law Live. Do you or someone you know have a loved one, perhaps a parent or some other loved one, who has passed on and left assets? It could be real estate or bank accounts, investment accounts, IRAs, CDs, whatever the asset may be as far as personal property that is titled and owned in their name only. Or maybe you have a loved one or know someone with a loved one who has passed on and left a will. If so, you will be need to know that you will be very interested in today's broadcast. The topic on today's broadcast is probate, the nuts and bolts of probate. In particular, we're going to be discussing the administration of estates, the assets of a deceased person in probate court. So in that instance where you either have a will or property that's been left by one who's passed on, a deceased person, titled in their own name, then you cannot transfer those assets to the heirs of the deceased person without going through the probate process. Now, how do you begin the probate process? Well, you begin the probate process by filing one of three documents. First, you need to know if the property of the deceased person is $40,000 or less, and that's in the state of Missouri. The document you file is an affidavit for collection of small estate. Again, that's the affidavit for collection of small estate. Now, you should know, and this applies for this topic, is that you need counsel, an attorney, to assist you with probate. That's not optional. At least here in Missouri, both the probate division of the City of St. Louis Circuit Court and the probate division of the St. Louis County Circuit Court require that whoever files the affidavit for collection of small estate or any other documents, or if you initiate the probate process, you need to have an attorney of record. So this is not something that you can do without the assistance of counsel. That is probate administration and probate, wills and trusts and so forth. Is, if many of you know who's watched the broadcast, is one of my areas of practice, and you can certainly contact us for representation if you need to do that. Also, let me mention two other things before we get in further into our topic. One is that you can, we invite you to let us know which topics that interest you, that you want us to cover in future broadcasts. So just contact us, email us or go to our Facebook account and tell us your topic of choice. You can email us at mraymondattorney@sbcglobal.net. And you can contact us by Facebook. That's facebook.com/Raymond Law Live. Or you can tweet us at Twitter at Raymond Law Live. So during the broadcast, we invite you to let us know what topics you want us to cover in the future. And the second thing is that if you have a question or a comment about our topic today on today's broadcast or other topics we've covered, then you can post your questions on Facebook. That's facebook.com/Raymond Law Live. Now let's get back to our topic for today, the administration of probate estates. So we mentioned that the first document you can file to begin the probate process is the affidavit for a collection of small estates. Or secondly, if the value of all of the property and assets of the deceased person is over $40,000, and again, that's in the state of Missouri, then the document that you file is called the application for letters of administration. And that is filed if the deceased person did not leave a will. So if the deceased person did not leave a will, then the document you would file through your attorney would be the application for letters of administration. That's what it's called if it's filed in the probate division of the city of St. Louis, Missouri. And if you file it in the probate division of the St. Louis County Circuit Court, then they call it a petition for letters of administration. So application for letters of administration or petition for letters of administration. And that must be filed within 1 year after the date of death of the deceased person. Again, within 1 year. The law, as you know from prior broadcasts, has time limits for everything. So for the petition for letters of administration for no will is 1 year after the date of death. Now, the third document you can file, or that should be filed, to begin the probate process for a deceased person is called a application for letters for letters testamentary. Application for letters testamentary. And in the St. Louis County, of course, it would be petition for letters testamentary. That is filed if the person left a will. If the person left a will. So no will, petition for letters of administration. If there is a will left by the person who is deceased, then it's petition or application for letters of administration. And again, as with the letters or application for letters of administration, the application for letters testamentary must be filed within 1 year after the death of the deceased person. And again, that applies the second two things for deceased persons whose assets are valued at more than $40,000. So that would be what we call, or what we refer to as a full estate, as opposed to a small estate. Small estates being when the assets of the deceased person are valued $40,000 or less. Now, if in the case where you have a petition for letters of testamentary, of course you have to locate the will of the deceased person, the original will, and that must be delivered to the probate division of the circuit court. And the court where you would file it would be the court in the county where the deceased person was domiciled. And domicile simply means the place of the persons, or the county of the persons, where they permanently resided or intended to reside indefinitely. Now, a deceased person has only one domicile. A person could have homes in more than one place or reside in more than one place, but the place of domicile is considered the permanent residency, or where the person intends to reside permanently or indefinitely. So once now, who is entitled to file for probate or initiate probate proceedings? Not everyone can file for or is entitled under the law to file or initiate probate proceedings. The first person who is entitled to file probate proceedings or initiate probate proceedings would be the surviving wife of the deceased person. If there is no surviving wife or spouse, it could be, if it's a man, of course, it would be surviving wife. If it's a man, it would be a surviving husband. So the surviving spouse is the first category, and if there is no surviving spouse of the deceased person, then the next class of people who are entitled to file for probate would be the children, adopted or biological children of the deceased person. We're talking about lineal descendants. In-laws don't count. The person has to be a lineal blood descendant, either a biological child of the deceased person or an adopted child. So that's the second class. Now the next class of persons, if there are no surviving spouse or surviving children, then the next class of persons who are entitled to initiate the probate proceedings would be the parents of the deceased person or the siblings. They're all in the same class, parents and siblings of the deceased person. Now, and that's true whether or not the person left a will. Also with respect to children, the descendants of the children are also entitled to file or initiate probate proceedings, and that would be true in each category if there are children. And then if there's a deceased child of a deceased person who has living or surviving children, then, or maybe the children are not surviving, but the children have children of their own, who would be the grandchildren of the deceased person, then they would be entitled to initiate probate proceedings as well. Now, if the surviving spouse or any other person entitled to administer your estate do not want to do it for whatever reason, then that person has the option of filing a renunciation and consent with the probate division, giving up the right to administer the estate in favor of someone else whom they have to designate and consent to. So, if, for instance, a surviving spouse decides that they do not want to administer the estate for whatever reason, then they can designate another person to do that. They can consent to another person. You have to file a consent with the probate division, and it has to be a written consent. And in addition to the person, the surviving spouse giving up the right, all the other heirs or all those who are entitled to receive a distribution from the estate have to also agree. So if there are other heirs beside the surviving spouse, then all of the other heirs are the lineal descendants of the deceased have to also consent to and agree upon another person who is going to do it. So you need a written consent and a renunciation. So once either the affidavit for a small estate or application for letters of administration or testimony or file, what happens then as far as the probate process? Now, whoever files the petition or application and initiates the probate process will have to file a probate bond with the probate court unless otherwise provided in the deceased person's will. So if the will provides that a person can be appointed to administer the estate without bond, only in that instance is the person not required to file a probate bond. And what amount of probate bond needs to be filed? The amount of the bond will be the value of the assets in the estate. This is the personal property in the estate, whatever that personal property is. Real estate doesn't matter. You can't run away with real estate, so the probate court is not concerned about real estate. Only the personal property, i.e. money, CDs, bank accounts, investment accounts, etc. Only those CDs and so forth, only those out of the amount of those things count as far as setting the amount of the probate bond. And once the probate bond is filed by the person who files the application or the letters, then the court, the probate division, issues a document and called letters of administration if there's no will, or letters testamentary that is issued. and appointing the filer, whoever filed the initiated probate proceedings, appointing them as personal representative or executor. The technical term for a person appointed is personal representative. It's commonly known as executor of the estate or executrix if it's a woman of the estate. So we refer to it as personal representative. So the letters are appointing the personal representative are issued by the court, and also beside the letters and the notice of the appointment, the probate process is such that a notice of the appointment of the personal representative is published in a newspaper notifying the world of the appointment of the personal representative. And also there's a second notice in the publication of the appointment, and that is a notice to all creditors, and those are anyone who is owed a debt by the deceased person. There's a notice that they have 6 months from the date of the first publication to file their claim against the estate of the deceased person. So any creditor who is owed money by the deceased person, not the personal representative, by the deceased person, then they are required to file a claim for the amount owed for the debt in the probate division within 6 months after the publication of the notice of the appointment of the personal representative. Now, if you don't meet that 6-month deadline, then you cannot file the claim, and the estate, the personal representative, does not have to pay. They're not legally required to pay the debt or the claim. So no timely filed claim, the estate is not obligated legally to pay the debt, which has to be presented to the probate division in a claim that's filed with the estate. Now, so we have the appointment, then we have the notice of the appointment and the notice to creditors. What happens after that? Then the personal representative, and this applies to all personal representatives, whether or not they are operating under a will or even a small estate or without a will. They have certain duties, and it's only 2 or 3 main primary duties, and this can get it's somewhat involved, but basically the first duty of the personal representative is after they file the petition, file a bond, and get appointed by the probate court as personal representative. Their next duty is to pay the debts of the deceased person, that is, the debts that are for which claims are filed. That's the first duty. And also, head of debts, the personal representative has to pay the expenses of administration, and that would be the court costs, which includes the filing fee, and also attorney's fees are considered expenses of administration. There are others, the cost of publication and so forth, but those are the main ones as far as expenses of administration. The court costs, the attorney's fees, and that comes that's paid in priority before the claims of any creditors are paid. Now, in some estates, not all estates, it occurs that claims are filed by creditors, but should there be claims filed, then the personal representative has to apply the assets of the estate to pay those claims, such as the assets are. Now, you should know that the personal representative is not responsible personally for paying the debts of the estate. The debts are paid from the assets of the estate, and only to the extent there are assets. So, if there are no assets in the estate from which to pay claims after the costs of administration, which come off the top, are paid, then of course the debts of the deceased person cannot be paid. So, duties of the personal rep: first, pay the cost of administration and any debts of the decedent which for which claims are filed. Now, once the debts, the cost of administration and debts are paid, the only other thing that the person representative has to do, and this is the primary duty, is to collect the assets and then distribute. Oh, before distribution, the person rep has to file an accounting with the probate division. It's called a final settlement. So they have to file an accounting of all receipts, whatever monies and property that's part of the estate that have been collected by the person representative. They have to list all of those on the settlement or the accounting, and they have to file the accounting. They also have to list on the accounting a second thing, that would be all disbursements from the estate. Disbursements would be monies paid out for expenses of administration, for attorney's fees, for any kind of costs. Also, you have to list any monies paid for claims that have been filed against the estate. So all of that, all receipts of the estate and all disbursements have to be listed in the settlement or the accounting, and that is, of course, provided to all persons who are entitled to distribution of the estate. Don't forget, if you have any questions or comments, you can post them on our Facebook, and we'll try to answer your questions or comments before the broadcast ends. So, the final accounting or final settlement listing all receipts and disbursements, excuse me, has to be filed, and the final duty of the person representative is to distribute the estate or the balance of the estate, the assets in the estate, after payment of the expenses of administration and the claims of any of the creditors. So that's whatever is left after paying those two things, or two categories of things, then that is what is distributed, if anything, to those entitled to receive a distribution of the estate. And that's what happens with full estates. It's a little bit different. Well, the distribution is made for small estates as well, but the process is a little bit shorter. So, and the person representative, with the assistance, of course, of the attorney, they file the accounting with the probate division, and a copy of that goes to those who are entitled to receive a distribution from the estate. And that is the last thing that the person rep does. And one other document that they file besides the accounting or the settlement would be the listing of the distribution of the assets in the estate, in what amount or what share each person who is entitled to distribution receives. So that's called a proposed schedule of distribution. So whatever is left, it is divided up among all of those entitled to receive a distribution. Now, in case, of course, if there's a will, then the person representative makes the distribution of whatever assets there are in accordance with whatever the deceased person has provided for in the will. So, in the will. So if there's a will, then you have to follow the instructions of the deceased person and distribute according to what's in the will. And that could be in any amount that the deceased person indicates. It's no equal distribution. They only get the persons entitled to receive whatever is stated in the will. Now, of course, that's not the case if there is no will. Then in that case, the person representative has to make the distribution equally to those who are entitled to receive a distribution from the estate. So that's the last thing, the distribution, a proposed schedule of distribution. And let me mention one last thing before we wrap up, and that is what happens with a distribution of a small estate. That's a little bit different. With the small estate, the personal representative does not have to file a final settlement or accounting. In a small estate, it's not a personal representative. It's the person, it's an applicant who files the affidavit for collection of small estate. So they have to, of course, collect the assets and pay any debts of the deceased person from, of course, the assets of the estate. And after they do that, the probate division, they just issue a certificate authorizing the personal representative, without an accounting and without a proposed schedule of distribution, authorizing that person to make a distribution of the estate. And if there's a will with respect to the small estate, then of course the applicant has to make the distribution in the small estate in accordance with the will. Now, what is a small estate as opposed to a full estate? We have a question about that. A small estate is an estate where the value of the assets of the deceased person, the assets owned by the deceased person, is $40,000 or less. $40,000 or less. So if all of the property owned by the deceased person at the time of death is $40,000 or less, then you can follow the more streamlined small estate procedure, which is shorter. You can get that handled sometimes in as little as a month or two, whereas with a regular or full estate, you have to, once the appointment of the personal representative is made, then you have the claims period, which is 6 months. You have to wait full 6 months after the estate, the date of publication of the appointment. You have to wait that whole 6 months before you can proceed with the administration of the estate. So that will conclude our discussion on today's topic, the nuts and bolts of probate. And let me say before we close, thank you all who watched this broadcast live, and also thank you those of you who will watch the broadcast at a later time for watching and for your interaction. Our next broadcast is going to be on Tuesday, April 9th, Tuesday, April 9th at 6 p.m. Central. You can contact us with any comments or questions, or if you need personal representation, you or someone you know, then contact our office. The office telephone number is area code 314-534-2800, or you can reach us on Facebook. That's facebook.com/Raymond Law Live, or you can reach us on Twitter at Raymond Law Live. So again, thank you all, and remember, when you fight, know your rights. See ya.